Hello folks, welcome back to the Wikipedia world, and I am Abhinay Gupta. So today we'll continue with the topic, the winding up. And let me remind you that for this chapter we would refer to the provisions or to the sections from the previous Companies Act, that is the Companies Act 1956. Right? So in the previous lecture, what we have done, we'll go through a quick revision of that, and then we'll move on to the discussion of the last portion that was pending in the previous lecture, right? And then continue with the questions. So in the previous lecture, we had seen section 425, the modes of winding up. So there are basically three modes: compulsory winding up, voluntary winding up, and the winding up subject to supervision of the court, right? In which the voluntary winding up is divided into two categories: the members voluntary winding up and the creditors voluntary winding up. Then we had seen section 433, the first mode, that is the grounds of compulsory winding up. So over here we basically have 6 grounds. Number 1 is a special resolution passed by the shareholders of the company. Right? So the shareholders, they may pass a special resolution and that would lead to a compulsory winding up. They would go to the court with that special resolution and court would order winding up. But we have seen that in general, what they would prefer is the voluntary winding up instead of a compulsory winding up. Right? Next, the default on filing statutory report or holding statutory meeting. So basically this provision is applicable to the public company. They have some certain statutory reports to be filed with the registrar, certain statutory meetings to be conducted. If they do not do it, then that may result to compulsory winding up. But since the court does not always want to award winding up, so what they would do is they would give them an additional time to hold that statutory meeting or to submit that statutory report, right? And we have also seen that after lapse of 14 days an application can be made and those kinds of provision. Next, no commencement or suspension of business. So if the business is incorporated, if a company is incorporated, it has to commence its business in the period of next 1 year. That is very logical, right? And if they do not do it, then they should specifically explain the cause, right? And their intention that yes, they would cover it up or they would start the business very soon. Or else if there is suspension of business, even that is for the period of 1 year, right? So in both the cases, if the company gives a valid explanation that no, in the second case that we will continue with our object, there was certain difficulty due to which we could not continue, but we will continue it further. So the court would not award winding up to them, right? Next is the reduction in the number of members below statutory minimum. So for public company it is 7 and for the private company that is 2. If the number of members they fall below the statutory minimum, then the court would have to order winding up to the company. Fifth ground was the company is unable to pay its debt, and we had seen that the minimum amount is rupees 500, and if they are unable to pay it for 3 weeks, then that would call for winding up of the company. But for that, the creditors will have to prove that yes, they had demanded. How will they prove it? They will have to furnish a notice to the company. They'll have to sign the notice and furnish it via a registered post to the registered office of the company, right? And then the court may either give them some time to continue or else order winding up. The last ground that we were referring to in the previous lecture was the just and equitable to wind up the company. What would be just and equitable? That would be upon the petitioner to prove that this is the last resort and we don't have a remedy available. We don't have an alternative remedy. So you will have to wind up the company. But if the court finds out any alternative remedy, they would award that remedy to the company, right? Or if they find that the petitioner is unreasonable, then they would not order winding up. Now we were to discuss the 5 examples and we did not cover it up in the previous lecture, right? So from here we'll start our class of the day. The first example we had was the loss of substratum. So loss of substratum would basically refer to the loss of the objective. That means the company which was incorporated to fulfill certain objects for certain purpose, right? And those objects were also referred in their article. So the substratum of the company that would be said to have gone for a toss if the main purpose for which the company was incorporated or formed becomes impossible. That means it is permanently impracticable. Now it is not possible for the company to achieve its objective or achieve the purpose for which the company was created. Right? So if that object, if that purpose is defeated, then we would say it is a loss of substratum for the company. And we cannot have a generalized rule to decide how we'll consider or when we'll consider the substratum to have been lost. That is always case specific, because every company is incorporated for a different purpose. Right? So case specific, the court will have to discuss and decide whether or not the loss of substratum is a matter of fact in the case. Right? And the winding up order would be given by the court if it was established that the company was incorporated for certain purpose and that is impracticable now, right? Which could no longer be achieved, that is impossible, right? Or if it is impossible to carry on the business of a company in a profitable sense. That means if you continue the business, first of all you cannot, but even if you continue the business, then you would only suffer loss. So there is no point of continuing the business, right? When you know that for as many years as you are working, you will be working for a loss. So who works for a loss? Nobody, right? So for those kind of companies would be subjected to winding up procedures, right? Because they know that this company can not make profit, cannot at all make any profit in the future. So that is loss of substratum. I hope it is clear with you. Basically, when you consider the term loss of substratum, consider the loss of purpose, the loss of objective, the impracticability of fulfillment of objectives, right? Next, we have a deadlock in the management. So who is the management of the company? The board of directors, right? So basically, if there is a deadlock in the management, in the board of directors of the company, then the matter is referred to the members, right? We have already seen that in the chapter of directors when we were referring to that chapter. But now if there is another deadlock in the management as well, in the members, shareholders as well, that means the company is not able to perform. Half the people are saying we would do this, half are opposing it. So it is a deadlock. The company is not able to move ahead. It is stuck over there. Right? So now the court will not come and decide, okay, you continue or you discontinue the operation. The court will say, please wind up. Because you people are not in a position to handle a company. Half of you are agreeing to it, half of you are disagreeing to it. So this company cannot function. It's better wind up this company and half of you please go ahead and start some other company, half of you go ahead and start some other company. That is not given in the section, right? But what I mean is that if there is a deadlock which cannot be unlocked, then the court will have to order compulsory winding up, right? Next is the fraudulent or illegal business. So if the company is incorporated, right, for a purpose and they show that they will carry on certain business, right, so they have to show a lawful business, otherwise incorporation will not be possible. So they showed a lawful business, but they are undergoing an unlawful practice. Maybe they showed a business of importing certain goods, but they're not importing it from the custom port. They may be smuggling that good, right? So that would be considered as an illegal object or fraudulent business, right? Now there can also be a situation where the company was although registered or incorporated with a certain objective, with a certain business in mind, right? They have declared that yes, this company is incorporated for this business, and that was a lawful business at that point of time. But now consider 3 years hence, there is an act that has come up and it says that this object or this kind of business would be considered to be illegal in India now. So what happened to it now? Although it was legal 3 years back, but now it is illegal and hence it would be subjected to winding up, right? So I cannot give you a case of a company in that scenario, but consider the recent case of Maria Sharapova. What happened was she was consuming a drug that was legal. For her medical health benefit, she used to consume that drug for a long period of time. But recently, the department has declared that drug to be illegal and she continued. Right? So that is illegal now. That would be the case with the company. Right? For example, another example, if I say there is a company, although this act is an Indian act, right? But I would share an example that is from US. Basically, consider a company in Colorado. Colorado is a country where marijuana is legal, right? So there are companies that are operating or they are in the business of processing marijuana or making medicines or drugs out of marijuana, right? But one fine day, Colorado declares that business to be illegal. They say that marijuana will not be allowed in my country anymore. What will happen? The object of that company will become illegal then, right? So if there is such condition available, applicable in India, then the court has just one remedy, which is winding up the company, right? Next we have the company is a bubble. What do you mean by the term bubble? In literal term, you know, the bubbles that pop up. All of you know what a bubble, the water bubbles and stuff, right? So over here also we are actually referring to that specific word. We don't mean anything else when we talk about bubble. This means that the company has a very thin outer structure and it is hollow from inside. That means the company do not have any profit, they do not have any object, they are not carrying on any business, right? That is when we call the company to be a bubble. It would pop up at any point of time. So it is better pop it up now, wind up that company, right? And final is the recommendation by BIFR, the Board of Industrial and Financial Reconstruction. So if that board at any point of time finds that any particular company is not fit to operate, maybe that is hampering the industry or its financial reconstruction is not proper, right? Then they would recommend the court to wind up a certain company, then the court would wind up that company. There is no remedy available with that company anymore, right? So these are the 5 basic examples when we talk about the just and equitable ground of winding up, right? And remember, whenever there is a petition filed to the court for compulsory winding up and the court finally decides that yes, the company needs to be wound up, then in that case, always remember that the date of commencement of winding up would be the date of the petition. So once the court decides that yes, we would wind up the company, the court would make a reference that the commencement of the date of winding up would be the date of petition. So the court will declare that yes, this is the date when I had received the petition and that will be the date for commencement of winding up. So the entire act of winding up will cover all the activities that has occurred in the company post that petition that has been filed, right? And the power to order winding up is basically discretionary in nature for the court. So that is one thing you will have to keep in mind while answering the questions, right? So that is all about the provisions of section 433. And now we will commence with the questions, right? So now we move on to the questions based on the section 433, the grounds of compulsory winding up, right? So the first question that we'll take up for the day is a question from CA Final May 1998, right? And the same question is also provided in your practice manual if you refer to the question number 4, right? So if you refer to the question in 1998, the dates also pertain to 96, 97. Right, but over here we have picked up the question from the practice manual where the date pertains to 2006, 2007. Right. So let us go through the question. The question is on your screen. XYZ Limited has its subsidiary company PRM Limited, which is formed to carry out some of the objectives of XYZ Limited. Right. So they have formed a subsidiary with certain objectives. Okay. XYZ Limited suspends one of its several business. Remember, it is not suspending the entire business, but just one of its several business. Right, that means even that one business is not a majority. How do they do that? By passing a resolution at the company's extraordinary general meeting, right? And that is done with effect from 1st January 2006. The business so suspended continues to be suspended until March 2006. That means for 3 months, right? 1st January to 31st March. On 1st April 2006, a group of shareholders of XYZ Limited file a petition to the court for winding up of the company on the ground of suspension of business by the company. Referring to the provision of the Companies Act 1956, decide, number 1, whether the shareholders' contention shall be tenable. Number 2, what would be your answer in case XYZ Limited suspends all its business? Number 3, can shareholders of PRM Limited file a petition in the court for winding up of the company, that is the PRM Limited, on the ground that the holding company, which is XYZ Limited, has suspended its entire business, though PRM Limited has not suspended its business. So this covers your entire provision of point number 3 from section 433. Right? What was the ground number 3? That was if the company does not commence its business within a period of 1 year from its incorporation. right? Or if they at any point of time suspend the entire business for more than a period of 1 year, then that would be a ground for compulsory winding up. But if you refer to the question that is in front of you, then in the question, the company, right, they suspend their business, but that is just one business out of the several businesses that they have. So the company on the whole is operating, right? Just one segment is suspended. So does it have an effect? No, because of that one segment, you are not supposed to wind up the entire other business of the company. If you're talking about, for example, a manufacturing entity into textile, right? So they procure cotton, they produce the thread from that, right? From that thread they prepare the sheets of the cloth. From these sheets they do the cutting. From that cutting they again stitch the shirts, and then they brand the shirt and sell it into the ready-made market. Now they have stopped one of its business. That means, for example, say they have stopped making the threads. So now they purchase threads directly from the market and continue the rest of the procedure. So is it logical for you to wind up the company because they're not producing threads now? No, they're still into the business, right? So there can be any reason for stopping the production of that thread. So if you refer to your first question over here, whether the shareholders' contention shall be tenable, then the answer is no. You cannot consider the contention of the shareholders. Why? Number one, because the entire business is not suspended, right? Number two, it is suspended for just a period of 3 months. And both these facts of the question do not fall under the third ground of winding up. The next question, what would be your answer in case XYZ Limited suspends all its business? Even then, even if it suspends all its business, we cannot compulsorily wind up the company. Reason? It's been just 3 months for suspension. That is what we assume, right? When the question gives like this, you say, okay, we assume that the question is referring to the question, to the position given in the question, that okay, they suspended the business on 1st January up to 31st March. The question says about just one segment, but now we assume that you're talking about the entire business. So in that case, since it is a period of just 3 months, we cannot compulsorily wind up the company. And in the last case, the entire holding company is wound up, right? But the subsidiary continues with its operation. Now, would you wind up the subsidiary just because the holding has suspended its business? No. If holding has suspended its business, wind up the holding. I don't care. The subsidiary is still in operation, right? And winding up can only be done if the company suspends its business for more than a period of 1 year. And over here, don't forget about the period. The business is continuing. It is not suspended. So how could you wind up a company like that? You cannot, right? So when you go on to write your answer, you write down the provisions of section 433, that as per section 433, the third ground says that they will have to wind up the company if they did not commence their business for the period of 1 year after incorporation, or they have suspended the business for a period of more than 1 year, right? And then you go on with point number 1, 2 and 3, writing your answers, that in the given case, this is what has happened, and according to the provision, they do not comply with the requirements of the provision, requirements of the section, and hence they cannot wind up. That is how you frame your answer, right? It was a very simple question, just a lengthy question, because if this kind of a question appears in your question paper in the examination, this would take half a page. So you need not panic. So now we move on to the next question, and the next question is from your exam, CA Final May 2011. So the question is on your screen. Let us see what the question has to say. The registrar of companies in Mumbai filed a petition in the Bombay High Court for compulsory winding up of the Constant Overtrading Limited on the ground that a perusal of the balance sheet of the company as on 31st March 2009 revealed that its liability far exceeded the asset, and consequently the company is unable to pay its debt. So what is the requirement of the question? It says, examine with reference to the provisions of the Companies Act 1956 the various factors the High Court will take into account before the company is ordered to be wound up compulsorily, and whether there is any justification in the present case for the court to order winding up of the company. So this question pertains to your section 433, right? So which ground? It basically pertains to ground number 5, company unable to pay its debt. Okay, but do you think the question, right? So you have to examine the provisions of the Companies Act and you have to think think whether or not wounding up or that compulsory wounding up for this company can be done? I think no, and I have reasons for that, right? So if you look at the question nowhere says that somebody has come up to complain. The question nowhere says that the loan was due or the liability was due and the company could not pay. The question nowhere says about anything like that. What the company says is that the registrar thinks that because liabilities exceed the asset too much, so if all the liabilities fall due on the next day, so even if they sell off their assets, they are not able to pay. So is that a situation of the company? Will all your liabilities, all your creditors come on the same day, all your loans, all your debentures, everybody come on the same day? No, I want my money back. Will that happen ever? No. I'll not say no. Okay, 0.0001% chance, okay, that can happen, but generally that will not happen, right? So first, to answer to this question, what you will have to do is you will have to reply to the provisions of section 433, right? The fifth ground, that is the company unable to pay its debt. So first you write down the provision that okay, if the company is unable to pay its debt, the company can be compulsorily wound up, right? But what are the conditions over there? That there should be an amount of debt exceeding rupees 500, right? And the company did not pay it for the period of 3 weeks. 3 weeks from the date of demand. It is not talking about date of being due, date of demand. So whenever the creditors come and they ask for the money, you still have 3 weeks time. If you do not pay it within the 3 weeks, then only the creditors can file the petition. But they again had some other conditions as well. Yeah, obviously that the creditor will have to prove that they have given it, so they will send a notice to the registrar office. That is a separate issue. But the next thing is that that if the creditors fail to satisfy the court's decree, then no winding up will take place. But if the company fails to satisfy the court's decree, the court says no, you have defaulted in the payment of your debt, and the provisions of section 433 will be attracted. So if you prove that no, nothing such has happened, then you will not be wound up, right? And the last point in that was the company would be wound up only if it is proved for the satisfaction of the court that they are not being able to pay the debt, right? But now if you come back to the question, this is what you will write, that okay, these are the provisions of 433, and then you start your real answer. Then you say that yes, section 433 authorizes a registrar to file a petition for this case if the company is not able to pay its debt, right? One thing. So over here it says that okay, the registrar files a petition in the Mumbai High Court. It's okay, registrar can file a petition in this case, right, if they are not able to pay its debt. But now you will have to write down your points, your contradictory points, that no, they cannot be compulsorily wound up because of these following reasons, and then you jot down your reasons, right? Number one, that in order to conclude that the company is not able to pay its debt, we will have to prove that the company did not meet its liability as and when it fell due, when it accrued, or if the creditors came forward for their money and the company did not pay it in the period of 3 weeks. And then you will also say that as per the provisions above, none of the grounds have been satisfied to prove that company was not able to pay its debt. Then another point, that no creditors have come up to complain that okay, we owe so much to the company and the company is not able to pay. No such situation have occurred. And last, the main point that you're going to write is that just because your liabilities in the balance sheet exceed your asset in the balance sheet, that does not mean that the company is unable to pay its debt. Whenever we are talking about the company being unable to pay its debt, we'll have to make sure that the company did not meet its liability as and when it was due. But nothing of that sort has happened in the question, and hence the petition of the registrar will not be tenable by the court. Finish, right? So we have discussed the two questions, and now we go on to discuss what are the other questions that can be asked from this topic, right? So basically one more question can be asked on the same topic, that is the company unable to pay its debt. So look at the question. Mr. M furnished a legal notice for the debt worth rupees 400. Company could not satisfy till the conclusion of 4 weeks. M files a petition to the court. Will it be accepted by the court? This is a very short form in which I have given you the question. It is a detailed question over there, but this is the crux. So okay, if they did not pay for 4 weeks, that is a contravention. right? 3 weeks is the time limit given in section 433. But the minimum debt amount, the minimum amount due for payment was also declared over there. That was rupees 500. But in the given case, it is rupees 400 and hence it is not tenable. Right? So these are specific minute detail points that you have to pay attention on. Now moving on to the other questions. Can winding up be ordered if directors discontinue one of its business? So again, it is talking about one of its business. We'll again take back the same example of the textile industry, right? So as per that example, again over here, what are they doing is they have stopped manufacturing thread from the cotton. They procure thread from the outside market. Now from that thread, they are making those sheets, than that you call. From that sheets of cloth, they are preparing shirts, they are branding it and they are selling it into the market. So everything is going very well. Maybe for cost efficiency or due to the lack of expertise or the machineries, they have just shut down one of their production process and others are continuing very well. So that will not be a ground for compulsory winding up, right? Next question is, explain whether the following are debt. Number 1, contingent or conditional liability. So this is a very mediocre kind of a question, right? If you think it by yourself, will you consider a contingent or conditional liability to be debt? No, because they are still contingent. Their occurrence will depend on the occurrence of some other event. That liability becoming due will depend upon the occurrence of some other event that is being contingent. If that event occurs, maybe you will have to bear the liability. If that does not, you will not. Again, the conditional liability is the same thing. If that condition is fulfilled, you will be liable, else you are not. So at the current situation, at the present scenario, you are not liable at all, right? So the following are not debt. Next, again, you could be asked question on the same thing. Non-payment of dividend declared or non-payment of salary to the employee. Are they debt? So basically, you will have to understand what happens when you declare dividend. So basically, when you are declaring dividend, right, you are not generating any wealth for the company. It is just the transfer of the profit, transfer of the money, transfer of the value, right? So if their shares were for rupees 100 in the company, now the company shifts that 2 rupees from each share to your account, because you cannot use that money which is in the company's account, but now company shifts rupees 2 to your account out of that, right? The value remains constant and the dividend comes to you. So the company has declared dividend, and once the dividend is declared, the dividend has to be paid, otherwise it's a default. That is why when the dividend is declared, even after your balance sheet date, then as per AS4, right, and as per subsequent event, you will have to show it in the balance sheet as liability. So once the dividend is declared, it becomes your liability, and since it is a liability to pay off something, it is a debt for you. And the next top point in the same question was salary to employee. Now understand one more thing. Salary is a regular operating expenditure, employee benefit expenditure that the company is making, right? It is not a debt. The company did not borrow anything from anybody. It is operating expenditure, right? So obviously the salary becomes due for payment. It becomes a liability for you. That okay, you have to pay the salary. Salary has accrued, but that is not a debt for the company, right? And the last point you have is the non-payment of the creditor for disputed liability. So over here the word to catch is the disputed liability. That means you say it is not worth paying. It is not our liability. We are not supposed to pay for that. But the creditor says no, I will receive the money from you. Like when does this situation arise? If you are purchasing something from some company. Creditors are basically suppliers, right? You are liable to pay money. So they dispatch the good, and on the midway, right, due to an accident, the goods got destroyed. The goods are spoiled now. It is of no use for any other party, right? Their terms of agreement, the contract of sale, was not very clear, and so they could not decide whether it was the duty, the liability of the supplier or the company. When did the risk and reward get transferred was not clear, right? So the creditors, they think that the company will pay me all the money. The risk and reward got transferred as soon as it was out of my warehouse, but the company says no. The risk and reward will get transferred to me once I receive the goods, but the good is in the middle way. Hence there is a dispute, right? Now what should happen? In this case, the court shall consider three principles, right? Number one, whether the defense of the company is in the good faith and is of some substance. So they are talking sense. Look at the contract. The agreement of the contract, the agreement or the terms and conditions are supporting the company. Number two, whether the defense is likely to succeed in point of law. Yes, because if it is written in the contract, it would succeed in the point of law. And the last point is whether the company has produced prima facie proof of the fact on which the defense depends. So if that fact is legible, if the court depends on that fact, they will rule out this, and hence that will not be the debt for the company. Right? Got the point clear? So contingent and conditional liability, they are not debt because they are still yet not liability. They will become liability on the occurrence of that condition or on fulfilling of some facts. That is contingent. Right? Non-payment of dividend becomes your debt as soon as you declare it. That will be debt, but non-payment of salary will not be debt. And non-payment of creditor for disputed liability will not be debt unless and until the dispute is cleared. And if it is in favor of creditor, it would be debt. If it is against the creditors, then it's out. You don't have to pay anything, right? So I think that will be all for the day. We have discussed 4-5 questions on this topic and we have covered the entire provision of section 433, the grounds of compulsory winding up, right? So with that, I'll take your departure. Stay tuned for the next lecture. We have other topics coming up over there. And until then, this is Abhinay Gupta signing off. Thank you. Bye-bye.